Hello, welcome to Pro Bono, sponsored by Cahoon Legal. I'm your host, Amber Cahoon. I am an attorney in North Texas, and we have new podcasts available every month, and you can subscribe on most podcast platforms and find us on our social media pages. Follow us at Pro Bono Show. Remember, this podcast is for informational and educational purposes only and should not be considered legal advice. It is not intended to replace a professional legal counsel or their advice. And this information is catered towards Texans with a focus on Texas law. What we have for you today is probate. We're going to be talking about the probate process and some basic information about it. Assets that might be exempt from the probate process. What if you don't have a will and you only have a house? What do you do? Or if your loved one who passed away, that's all they had. And then if there's no will, what do you do with your loved one's property? And then we're going to do another fact or fiction. And then I'm going to talk about a reality TV show that my daughter just introduced me to. And then that will be it. So let's get started. So probate is a process for the assets and estate of the loved one that has passed. So the person that has passed, they are called the decedent, and either a family member or the person listed as an executor or personal representative in a will, anything like that, can contact an attorney. In Texas, to actually go through probate, you do actually have to have an attorney. Texas has a couple different options, and so it's important to contact an attorney because your particular situation or the decedent's particular estate may not need to actually go through the process because probate is a court proceeding. But if you have a will, you have 4 years from the death of the decedent to probate that will. And if you do not have a will, then you still can go through the probate process. It would just be under the intestate code, which is the Texas Estate Code. There are codes for people that did not have a will, and that they're called intestate. And they will go through that process. So again, you do need an attorney if you are going to go through the probate process. But what the first thing is you need to find the original will, if there is one, and you need to provide that to the attorney. They will submit an application to the court, and they will actually take the will or have someone take the will down to the courthouse and have it filed. Then after a certain period of time, you have to post a public notice for creditors or any heirs that are not aware of the person's passing. The court has a hearing where what would be a executor or personal representative, the person who is putting forth, the will to be probated, will be questioned by the attorney. Any witnesses on the will need to be found and testify. Or if there isn't someone that was a witness that you can't find, then you can bring different people that can attest to the decedent's state of mind, and if it looks like their handwriting, that kind of thing. Again, this is general information, so really reach out to an attorney for more specifics. But once that hearing's over, the attorney would apply for either independent administration or dependent administration. So usually if there's minor children, there will always be dependent administration. And dependent means that it will be more closely monitored and governed by the court and the judge. Independent, it's a lot more independent, as the word indicates. After another certain period of time, you need to file the inventory of all the assets. There are other things you can do if you don't want those disclosed. There's an affidavit in lieu of the inventory. And then you have to contact the beneficiaries and notify any creditors. And then once what are called the letters of testamentary, usually for a will that is probated, that's given to the administrator or the executor that's appointed, then you use those documents to actually contact the creditors, and they give you the authority to act on behalf of the estate. And you distribute the assets, or you pay the debts, you distribute the assets, and then you close the estate. That's a very general overview of probating a will. Again, the probate process, if you don't have a will, it will be slightly different. Now, let's talk about some assets that are exempt from probate. So, assets that do not go through the probate process are typically going to be ones that you have already designated someone to be a beneficiary, or they have what's called a pay on death or payable on death provision, or there's a right of survivorship, or there's some sort of post-death transfer. So most of those will include life insurance policies, some or most bank accounts. That's something that if you're putting together your estate plan, you need to make sure that the bank accounts that you have actually have a beneficiary listed. Sometimes that's automatic action by that company, especially for investments. That's usually done automatically, but some actual bank accounts, they don't have that. So if you're a husband and wife and you're in Texas, you usually will have a joint bank account, and there will be a provision for a right of survivorship. And that means that when one of the spouses passes, then the ownership of the account then transfers wholly to the other spouse. But these are important things to ask. You wouldn't want everything taken care of to avoid probate, and then you just have one bank account that wasn't done properly, and they still have to pay and go through probate because of that one bank account. That can be very time-consuming and costly. So there's things that you can do ahead of time in your estate plan to make sure that most, or if not all, your assets will avoid probate. So like I said, bank accounts, life insurance policies, investment or retirement accounts. And these are, like I said, they require you to name a beneficiary. There is another thing that is available in Texas, and it is for real estate or real property. It is called the transfer on death deed. And that is something that you can complete, and it's best with an attorney. And you file it in the property records where your home is located. So if you reside in Tarrant County or Dallas County, then you would file, or your attorney would file, that transfer on death deed in the property records of that county. And what happens is you would designate a beneficiary for your home. And so let's say that you only have that asset. So if you have the transfer and death deed for your real estate, then that can pass without going through probate and makes it much easier on your loved ones. Another thing is if you have a trust or one that is set up during your lifetime, then you can have the assets already into the trust and they would not go through probate. Some people don't realize that if they have an estate plan and they have what's called a pour-over will, so that means that the will says that everything will go into the trust and the trust will be created upon their death, that will still need to be probated. So if you're not sure if your current will has something like that, you need to have an attorney look at that. And if that's not what you're intending or you want to have happen, then you would need to change that and create the trust and start putting the assets in the trust before you pass. There is another thing, and it is actually done through the Texas Motor Vehicle Department. There is a form, and if you have a vehicle that you want to have passed without going through probate, then you can fill out that vehicle form, and it's like a transfer and death deed, but it's for your vehicles, or I guess if you have a motorhome or something like that, that's all under the Texas Motor Vehicle Department. And so they have a document, and I would look into doing that. So that if you have a vehicle that maybe it's a classic, you never intend on selling it, that kind of thing, or maybe you live in a manufactured home or something along those lines, that you can have that pass without going through probate. Okay, next, As I said, we'll talk about if you have no will and you only have a house, what can you do? So it is really best to have a will, but if you only have the house and you intend to stay in the house for at least a year, I would say, just to offset the cost, I would really recommend getting a transfer on death deed. If you decide to sell in 5 years and you get a new house, then you can do another transfer on death deed. They, aren't the most expensive, but they are, several $100s to get done usually. So it wouldn't be something you would want to probably do if you plan on selling shortly. But if you plan to stay in your house for a certain period of time, then it would be worthwhile to get that done if that's really your only asset that you have. Besides just the stuff in your home. Texas does also allow for what's called a small estate affidavit, and that currently the limit is $75,000 in assets or less. And there also have a provision about there is a total exemption amount. So there's it might actually be a little more than that because there's some exempt property allowed within that as well. So if you don't think you have a lot of property, you just have the house and maybe that's already taken care of, or your loved one has already taken care of that, and it's just stuff in the house, you might be able to avoid a complete probate process and just go through a small estate affidavit, but yet that does still have to be filed with the court. And so next, if there is no will, what do I do? If you're the loved one and there's no will, what do you need to do? As I said before, probate's a process, and you go through court, and basically the judge legally recognizes that a person is died and gives authority to a particular person to administer or manage and distribute the assets in the estate. And so if there is not a will, then you need to really understand the size of the estate. So all of the assets that are a part of it, whether there are any assets outside of the state of Texas, or if there's any assets outside of just the county in which the decedent passed away. One of the first things when someone passes away that you'll do is you'll apply for a death certificate. And that usually takes a few weeks. And so just be prepared that there is a little bit of waiting. And the probate process for someone that has a will can take months up to a year. And that doesn't mean that you'll be in court that whole time. Getting a court date, depending on the county in which you're in, if it's really busy, can take a few months or more. And then also, once you have the letters of testamentary, then actually contacting the creditors and taking care of and distributing the assets can take a little bit of time. So if there's no will, and you've established the type of assets that they have, if they only have assets like life insurance, bank accounts, retirement accounts, or the transfer and death deed that have beneficiaries listed, again, there may not be enough assets that you actually have to go through a full probate process, but it's important to contact an attorney so you can make sure to do it properly. Unfortunately, there are many people, especially with real estate and out in the rural, let's say your grandfather left it to his children, and someone's living on the property, and so it's already paid for. They're not worried about it. They're paying the taxes like they're supposed to, but the property never actually gets transferred into the children's names. And then let's say that one of them dies, and their children are wanting to do something. It becomes somewhat messy. And there are things that can be done if a will was not probated within 4 years, and if the estate needs to go through probate. Usually what happens if it's past 4 years with a will, then the estate is treated as intestate. So if there is a will, really you need to reach out to an attorney within those 4 years to get that done, so that whatever wishes that person had, you really are going to be able to follow them. Otherwise, it will revert to an intestate estate, and that may change the distribution of assets because it will follow how the law is, not necessarily how the person or the decedent had made the decisions. So next, we're going to do fact or fiction. And this is something that I hear quite a bit. And many people will say, well, I don't need to probate my loved one's will because they had a will and they listed me, and so I'm just going to take care of it. The problem is that there are many things that you cannot actually do without actually the authority to transfer that property. So when the will is done, then it has to go through probate so that you're given the authority to actually transfer those properties. Some things it's easy if it's, clothing and stuff, there's no real like title to it. But if there's a car, if there's real estate, if there's any accounts, to actually get access to those or to have the authority to sell, trade in like a car or anything like that, and to change ownership, you have to have that authority. And that authority can only come through the probate process for a will, and those what's usually called letters of testamentary or letters of administration. It becomes, as I said before, very messy, especially if there's real estate that has not been properly managed or distributed properly and transfer of ownership has not taken place. Another thing is that the wills are not necessarily public. So if someone has not probated a will and you think you're a beneficiary, it's not really easy to find out what the assets are. Again, if you are not listed, let's say you believe there was a will, and it's been a year and you've heard nothing, and maybe you had a parent that you weren't really close to, they're out of state, but you're like, I know they had assets. What's going on? There is nothing in the law that really bars a person from bringing a probate case. What will actually happen is if there is a will, they look to who's listed in the will. But if you don't have a will and you can't find a will and you don't know if there is one, you can still reach out to an attorney, because if you are an heir, you can actually bring for or apply for probate. I had a case where there was the siblings of the decedent came forward, and they were getting information, and in the conversation we found out that they had adult children, and so in that case I had to reach out to the adult children to see if they wanted to move forward, and they did. But usually you want to have the closest heir in line, and so usually how the inheritance is, the first is a spouse, and then second is the children, and then third it goes up to the parents, and then fourth is to the siblings. And so if there is, if you're not sure, and that's real basic, and it can be a little more complex than that depending if someone's died, maybe it's the children, but one of the children has already died, and so they have children. So it's really important that you contact an attorney. So that's some basics about probate, and I hope that was helpful. Now I'm going to share a little bit about what's been going on with me. We are preparing to travel. I talked about that last month, and I didn't know if we knew yet, but we're going to Charleston, South Carolina, which I'm really excited to see the Atlantic. My children have been off of school, and we like to watch TV shows with our kids. A show that we're watching currently with them, which is really funny, is Kim's Convenience. I believe it's on Netflix. It's about a Korean family. It's a comedy, and it is hilarious. So if you like to laugh a lot, it is very funny. Another show that I watch but I do not love is Dance Moms. My 14-year-old daughter started showing me clips, and it is wild. I've watched a few episodes, and it just sucks you in, and it is crazy. So if your daughter's in dance or your son is in whatever, great. But I just think that they're vile on that show, and maybe you agree with me. And I There's a girl in there, Maddie Ziegler, which I'm familiar with because she danced in Saya, who is a musician, and I like her music. So I was a little familiar with her. But watching that show is just, it's hard to watch, and it's crazy because there's just like abuse and negligence and just so much bad is going on from the dance owner, I think Abby, dance studio owner, as well as the moms. And it's crazy. Of course, it's reality TV. There's so many shows coming on that people are watching. And there's another show I was watching that was like the dating. I can't remember what it's called, but it is crazy. These people are crazy. I'm so glad to be married and not have to worry about dating in today's world. But anyways, that's just a little bit something about me. I don't really love reality TV because it just is, I mean, it's addictive. It's like you just sit there and like, oh my God, I've watched 2 episodes. And it's like, you know, I feel like I'm losing brain cells when I do it. And for me, I know I've talked about reading when I want to relax and just, you know, let my mind not work so hard. I love to read. So I just get into a real easy, fun, you know, romance or fantasy novel or whatever. So that's what I prefer. But because my daughter's been showing me, I have gotten sucked into watching some of those. So anyways, I do not recommend them, but I'm just sharing with you something that has kind of been going on with me this summer. Thank you for listening, and I hope you learned more about legal topics that can help you in your daily life. Please share with friends and family and send any questions you have that you want me to cover in future episodes. Next month, we will be discussing business law again, and we'll take a little different angle than we did in January when we covered it. Have a great day.